Now, the law of the seat is not about the physical place where the hearings are held. You can have an arbitration seated in Singapore, but the hearings are entirely in India. No problem. The law of the seat doesn't have to be Indian law. You can have an Indian law, you can have a contract governed by Indian law. So something that if you'll be more familiar with, but the law of the seat can be Singapore. That's not a problem at all. And the legal seat does not determine the governing law of the arbitration clause. So even the arbitration clause, there's a question as to what law the arbitration clause is governed by. Generally, the law of the seat does not automatically apply as the law of the arbitration agreement itself. Now, what should you think about when you're choosing a seat for arbitration? Now, the main considerations that are usually considered by parties are first, whether the jurisdiction is arbitration friendly, whether it's supportive of arbitration, or whether it interferes in the arbitration process. The second thing is you look for neutrality. Usually, you do not pick a seat in a country where there are two international parties. You tend to look to a third country. The third, geographic convenience, is a lesser consideration, but of course, if you pick a seat that is halfway or 3/4 of the way around the globe away from you, or halfway around the world from you, that might make things a little complicated when it comes to the supervisory courts or the interaction with the supervisory courts. So the common seats for international arbitration are London, Singapore, Paris, Stockholm, New York, Hong Kong. There are many others as well. But these, I think, the ones that are identified there will be considered to be the main ones. Now, another key concept that underpins arbitration, it's something I alluded to earlier. It is this. If someone who is party to an arbitration agreement, where there's a dispute, if that person goes to a court, the effect of the arbitration agreement is that the court must stay the proceedings that have been brought, so that the proceedings in court do not move forward, and the proceedings instead get resolved in arbitration. That is essential to protecting the integrity of the arbitration agreement. Now, in Singapore, we have two different statutes that provide for which govern arbitration. There is something called the Arbitration Act, which applies only to arbitrations agreed to between domestic parties. But for international arbitration, we have a separate regime. It's called the International Arbitration Act. And that act says that if a party brings court proceedings in breach of an arbitration clause, then those proceedings must be stayed automatically, unless there is some problem with the arbitration clause, or unless one party has waived its rights under the arbitration clause, basically. Now, one other concept that is worth discussing is the concept of ad hoc arbitration versus institutional arbitration. Ad hoc arbitration, rather the best way of illustrating it is this. Institutional arbitration is where the arbitration is managed by an arbitral institution. The key benefit of the arbitral institution managing the arbitration is it helps fill in the gaps between the parties. So let's say, for example, the parties are unable to agree on an arbitrator. It is the arbitral institution that would usually, in those circumstances, appoint the arbitrator. So what I was talking about earlier, the benefit of arbitration in terms of the specialization of arbitrators, it is necessary to have a good institution in order to enjoy that benefit. You see, because otherwise, who's going to appoint it? You don't know whether the person who's otherwise going to appoint will appoint someone with the necessary expertise. Now, institutional arbitrations carry another benefit. They often control the costs of the arbitration as well. So the SIAC, for example, has a scale of fees, and that scale of fees will tell you what the average cost for arbitrations of a particular value are, and it will also tell you what the maximum fees payable to the arbitrators are. And you can see all this just by looking online. There is, in fact, a fee calculator on the SIAC website. There are many other arbitral institutions who have similar information as well. Another key concept is that of the finality of the arbitral award. Now, the parties usually agree that the award will be final and binding, and that's usually the case with almost all arbitrations. However, the losing party does have certain rights. Now, what you cannot do is you cannot appeal against an arbitration award. Okay, you cannot appeal an award in the same way you can appeal a judgment in court. You cannot say that the arbitrator got the law wrong or made a mistake on the facts. You can only challenge an award for very narrow reasons. Most of those reasons are because the arbitrator didn't behave fairly in hearing the parties' cases. Okay? There was some procedural defect in relation to how the arbitrator conducted the case. The second is if the arbitrator decides something which he didn't have the power to decide. So say, for example, the parties to a construction contract agree to have their disputes resolved, and one of the parties then brings the claim in respect of another contract to do with some shipment of goods somewhere else in the world that there's nothing to do with that construction contract. If the arbitrator decides something like that, that kind of award cannot be enforced because the arbitrator didn't have the jurisdiction to make such a decision. The other ground which I'll just highlight to you is that the award, if the award violates the state's public policy, that is a ground. However, most of the pro-arbitration jurisdictions have taken a very narrow interpretation of the concept of public policy. Now, in the slides that you have, you will see that there is some discussion of the characteristics of the SIAC rules. I'm going to go through them very, very quickly, because some of it, I think, is going to be of particular interest. The first is this concept of early dismissal. So the SIAC rules contain a provision for early dismissal. What that means is that a party can apply and say to the arbitrator, look, you shouldn't go through a full arbitration process for this claim or defense because it is manifestly without merit, and therefore the best thing for the tribunal to do is to make a decision on the question of whether it's manifestly without merit so that the proceeding can be brought to an end quickly. That is a procedure that is commonly deployed in certain types of cases, particularly where one party is a very, very weak case. So an arbitration that would otherwise take a year to conclusion can then be concluded within 4 or 5 months instead. Other features of the SIAC rules are things like consolidations, where there are a number of different arbitration proceedings. There are also provisions with respect to where there are multiple contracts. There is something called the emergency arbitrator under the SIAC rules. And what an emergency arbitrator can do is this. Now, if you think about it, with arbitration, you need a tribunal to be appointed, right? Now, that process of appointing a tribunal can sometimes take a bit of time. Sometimes, though, you need emergency interim relief. You need an injunction very quickly. The emergency arbitrator is an arbitrator that is appointed by the SIAC on an emergency basis. So the appointment usually happens within 48 hours. The arbitrator then decides in a matter of weeks on the application for an interim injunction. If an injunction is granted, that injunction only has power, and it carries on, but once the tribunal is actually appointed, that tribunal can set aside or deal with that order as it sees fit. I'll just highlight one last thing about this and move on because I'm conscious of the time. One other key feature of the SIAC rules is something called the expedited procedure. The basic concept underlying the expedited procedure is this. If a claim is below a particular monetary threshold, and you can see that the current threshold is $6 million, Singapore dollars, the arbitration must be concluded. That is, an award must be issued within 6 months of the tribunal being appointed. So consider that. You file a claim, the SIAC appoints the arbitrator, 6 months later, you have an award. And that is a final and binding award that cannot be appealed. It can only be challenged on very narrow grounds. It has been an incredibly popular device under the SIAC rules. Now, the SIAC are putting together some draft rules which will apply in the future. They're considering some changes to the rules, including matters such as increasing the threshold of the expedited procedure from 6 million Singapore dollars to 10 million Singapore dollars. And that's because of how effective the expedited procedure has been. I won't go through all the proposed changes, but I'll leave that to your reading pleasure. So I'd be happy to field any questions on those changes if you do have them. Lastly, I'm just going to spend a few minutes on this, some tips with respect to drafting an effective arbitration clause. Now, the arbitration clause is incredibly important because arbitration is about consent. The clause is the expression of that consent. If there is a problem with the clause, you're not going to be able to draw that consent from anywhere else. So it is imperative that the clause is effective, that you get it right. Now, the two key elements are the clause must provide for an agreement to submit disputes to arbitration. And the second thing is it must provide for receipt of the arbitration. With those two elements, an arbitration clause will generally be effective. However, usually the parties provide more. First, you usually specify a set of procedural rules. Second, you usually specify the number of arbitrators that you want and how they are to be appointed. The third is you usually specify things like the language of the arbitration. Now, just some points to consider. One is you should avoid ambiguity, use mandatory language. It's very important to designate the law of the seat, and it is highly desirable to specify procedural rules. I won't go into the point about the law of the arbitration agreement because it is quite an involved point, but I will talk briefly about considerations when choosing an arbitration institution in the context of where you have decided that it is worth using an arbitral institution. And I should say I am a firm believer in arbitral institutions. I do not think ad hoc arbitration, while there is a perception that it is cheaper, it actually turns out to be more expensive in the long run because it results in a lot of delay. There are usually a lot of complications, and that tends to eat up and use up a lot of time, and therefore that creates more costs, the complications and the delay. So I would strongly recommend institutional arbitration almost every time. As to who you choose, that really depends on things like the specifics of the rules that the arbitral institution has, the extent of the supervision that the institution has over the arbitral process, and matters such as the fee structure and the location of the secretariat. One thing I will highlight from this particular slide is the importance of ensuring that the clause is not pathological. Now, most pro-arbitration jurisdictions will try and uphold an agreement of the parties to arbitrate, even if there are gaps in the agreement. What even the most pro-arbitration jurisdiction cannot do is make an agreement for the parties. It cannot substitute its own agreement for the parties' agreement. And that's particularly important because if the clause contains inconsistencies, contradictions, then the court court cannot cure them. So you can see there is an example here. You see, it says any dispute arising from or relating to these terms or any contract made hereunder shall, unless resolved between us, be referred to arbitration under the arbitration rules of the relevant institution or any other organization that both parties agree to. Now here, there's a huge problem because which is the relevant institution? We don't know, which means that the clause cannot be perfected unless the parties agree. Now, once the parties are in a dispute, they're not going to agree to anything, right? So a clause like this is not going to be effective because the court cannot fill in the gap that is left behind by the parties. So it's very tempting often to think that you can negotiate these little things in an arbitration clause. The general thing is that shouldn't be the subject of the negotiation. Actually, the best thing is usually to use the standard clause that is provided by the arbitral institution. that is a very clear way of indicating exactly what the parties have consented to. Now, institutions like the ICC and the SIAC have model clauses. You can see them on the internet. You can take them and copy and paste. Don't change anything. But the best thing is you can just copy and paste it into your contract. That will 99.999% of the time there won't be any problem. If there is a problem, it's not because of the clause. It's because there's some court that is taking a slightly different view of things than orthodoxy would suggest. And with that, I am going to stop and we shall move on to the panel discussion. Thank you. Sorry. Yeah. So I have with me the four gentlemen who have been introduced to Bala, Jainu, Srikant, and Ganesh. I'm going to begin by asking Ganesh this question. Now, Ganesh, we have spoken about how arbitration proceedings are supposed to be faster than court proceedings. But can I ask you, as a person who has significant experience in international arbitration, as well as arbitration in India, as well as experience of court proceedings in India, how long do international arbitrations take? And secondly, are they truly quicker than court proceedings?
Thank you, Avinash. Firstly, before I start, as litigators, we've been sitting on stage for some time and, watching everybody speak. Firstly, thanks to MMA, Captain Vijay Kumar, Group Captain Vijay Kumar, for this wonderful opportunity, and to Raja and Tan, Jainil, Avinash and Bala and Srikant. It's great to be speaking to this audience. Of course, before I answer this question, there's just one point I want to clarify. Mr. Vijay Kumar was mentioning about the arbitration he was doing on a daily basis when there is, some kind of a feud between, the kids and all that at home. Since we have a varied audience here, I see a lot of practitioners from the Madras High Court, say a very seasoned former in-house counsel and now a practitioner, Mr. Venkatesh, and good friend, who was one of the top in-house general counsels earlier of VFS and many other companies. But there are also a lot of students and others. So I thought this thing I'll clarify, because there's always doubt in the mind as to what exactly this arbitral process entails. What we are talking about, trying to negotiate and settle is more called a mediation or a conciliation. Now, under the Arbitration Act, though we have the word conciliation, we have a mediation act, and it's now become almost synonymous. There we try and settle the dispute between the parties without a binding decision. The mediator doesn't give a binding decision. Whereas in an arbitration, it is almost akin to a civil suit in a private setting. So you go through the entire process, right from the notice of arbitration to the pleadings and then evidence, and you have a hearing unless it's a documents-only arbitration, and the arbitrator makes his decision, his or her decision. The judgment in an arbitration is called an arbitral award. So they make an award, and it's enforceable not just in India but across several countries, more than 150 plus countries, because of an international convention which Jainil referred to, which is the Convention on Recognition of Foreign Awards, called the New York Convention. So I thought I will give this prelude so that arbitration is a full-fledged process. Now, that begs the question as to what Avinash asked me just now. How much time does it take? So here, when Honorable Justice Ramasubramaniam was speaking to us, he was referring to the White Industries case, though of course it's in the context of investment treaty arbitration. The basis on which the India, in fact, did not succeed in that matter was because of the delay that was there in the court proceedings. But now, when it comes to an arbitration, when a client comes to us, the first thing everybody wants to know here, all of you will agree with me that the first question on anybody's mind is how much time is this entire process going to take? And how much is it going to cost? So these are the two questions that everybody has on them. And when it comes to costs, mention that in brief before I go on to the time. Arbitration traditionally was believed to be a cost-efficient process, but now there are complaints that it has become as expensive or more expensive as litigation. In fact, just to give you a basic anecdote so that we are all, in terms with what the legal costs are today. One client just walked into one of the lawyer's office, maybe like Avinash, let's say, is a swanky office in Bombay, and he's here, and he goes into the office, and the client looks at the office. It's so swanky, and he's so afraid. I mean, if I'm going to engage this guy, how much should I pay him? So the first question the client asks him is, "What is going to be your fees?" So this lawyer answers him to his first question as to what the fees is going to be. He says, 1 lakh for 3 questions. The second question he asks is, don't you think this is exorbitant and atrocious? Well, just for 3 questions, you're charging me 1 lakh of rupees. He says, that could be the case, but let me know what your third question is. So, ladies and gentlemen, that is actually true today. We are thinking and we are sitting here, we are all lawyers. I think we should be conscious about the fact that alternate dispute resolution, parties traditionally were resorting to this because of cost efficiency and hoping it will be in a time-bound manner. But coming to the timeline now very quickly, fortunately, we have an amendment made to the Arbitration Conciliation Act in India with the introduction of Section 29A, where an arbitral award in an arbitration which is domestic has to be made within 12 months after the close of pleadings. For pleadings, we have 6 months' time under the Arbitration Act. And after that 6 months, you have 12 months for the arbitral award to be made, unless parties by consent extend this time by up to 6 more months. Beyond that, you need to go to court to get an extension of time. So that, Avinash, I can tell you, for arbitrations, now it's a great boon. And when we all started practice, many years ago in India, arbitration used to be fun for juniors because you just went, had, good meal, and then it would go on forever, on and on and on. But now it's not the case. Arbitrations are finishing, domestic arbitrations are finishing within a year, year and a half. And insofar as international arbitration seated in India, while 29A, when it was first introduced in 2015, had this provision also applied to international arbitrations. But after a lot of hue and cry, because it was quite tight for some of the huge, contracts and big ticket international arbitration. So now international arbitration in India, seated in India, are excluded from the purview of 29A. It's just that they need to endeavor to make the award within 12 months after close of pleadings. But I would say that on an average, it takes about two years in international, unless it's very, very, very complicated. So I think definitely I feel Section 29A is a great boon, and things are moving very swiftly for arbitration. It's perhaps the best thing that could have happened for Indian arbitration in recent times.
Thanks, Manish. Jaina, maybe if I could now turn to you. And perhaps just to ask you a question on the scope of challenging an arbitration award. As a matter of practice, because I think we went through some of the material about the grounds upon which an arbitration award can be challenged. But it's one thing to look at those grounds. It's another thing to talk about the actual practice of it. Perhaps you could talk to us about that.
Right. Thanks, Avinash. Right. The short answer is that for a Singapore seated arbitration, there are very limited avenues to set aside the award. For one, you cannot appeal on the merits of the award. In other words, you can't tell the Singapore court that, there's an error of law, an error of fact, and therefore the tribunal got it wrong. Please set aside the award. That is clearly not a ground in which you can rely on. So you can only set aside the award if you bring your case within one of the specific grounds that have been spelled out in the International Arbitration Act that would entitle you to set aside the award. So in that sense, the Singapore courts are very pro-arbitration. And basically what the courts say is that, look, if you have agreed to go to arbitration, then you must accept the judgment of the tribunal, even if it is incorrect. We will not interfere. And we will only interfere if a very clear case has been made out that there is a legitimate grounds of challenge. And I think Avinash had already touched on these grounds earlier, right? They're very limited, and they're limited to cases where there is no jurisdiction, excess of jurisdiction, where there's been a breach of natural justice, meaning to say a party has not been given a fair opportunity to be heard. But even in that situation, where you can demonstrate that you have not been given a fair opportunity to be heard, you must still show actual prejudice, meaning to say that you must show that if the tribunal had given you that opportunity to be heard and had taken in your submissions, there is a reasonable chance that it would have led to a different conclusion. So in other words, if you were not heard on something that was inconsequential or not very relevant and would not have affected the tribunal's decision, then even though you can say technically there's a breach of natural justice, it's not a ground to set aside the award under Singapore law. And lastly, public policy. Why I say public policy is because in some national courts, they take a wider definition of what is public policy. And even an error of law, right, can be regarded as a breach of public policy. But in Singapore, public policy is very narrowly defined. It's defined as such that, it must be something that is either immoral, illegal, or shocks the conscience. For example, where there has been fraud in obtaining the award, where there's evidence of bribery, right? Where the contract is for an illegal or immoral purpose. So in these situations, the court will say, okay, the ground of challenge is made out and we will set aside the award. So most challenges in Singapore will fail.
Thanks, Daniel. Srikanth, can I turn to you?
Sure.
This is a question from the audience. Could you elaborate on the challenges and strategies for enforcing foreign arbitration awards in India? That's really the question, and it sort of follows on from what Jaino was talking about. And so, if you could,
yeah, perhaps I just touch upon the methodology that's carrying on from what General said as far as challenging arbitral awards in the context of India. Before I answer the question, much as General elaborated in the context of Singapore, you will find that in India too, because it is what is known as a model law country. The references to the UN Convention, which General had made in the presentation earlier, India follows very similar standards in respect of what are the grounds for challenging an award and they are extremely limited again. Now, General touched upon the usual challenges that flow from natural justice violations and so on, and then he clearly stated that the award will not be challengeable on merits or a mere misapplication of the law. Those standards very much are followed in India as well with respect to India-seated arbitrations. The other quick point that General made was with respect to public policy. The only distinction I would like to draw with respect to how the public policy ground in India is enforced as opposed to, say, Singapore, is that there seems to be a slightly wider interpretation that is generally entertained by the courts. And that said, there have been a series of cases that have actually allowed for the jurisprudence to be standardized. But here I must make a distinction. It's possible for an India-seated arbitration to be an international arbitration where the parties are, you have parties which are not necessarily domestic. And you could also very much have an India-seated arbitration to be completely domestic. In the context of international arbitrations which are seated in India, you don't have the ground of challenging the award on account of patent illegality on the face of the award. Whereas for domestic arbitrations which are seated in India, patent illegality is certainly a ground, but again that does not extend to a situation where you're merely challenging the misapplication of the law. It has to be something way beyond that. I'm not sure if I answered the question yet, but could you repeat the audience question? So I want to make sure I get that.
Yeah.
Yeah, so foreign awards in the context of enforcement in India is, as was referred to earlier, India is a party to the New York Convention, and therefore, so long as the foreign award follows certain basic principles, A, it was in pursuance of a valid arbitral agreement, it was between persons regardless of what the domicile is, what their residency status is, so long as the award was seated in one of the NYC member nations, and it was actually made in pursuance of a valid arbitration agreement, it is recognizable in India for the purposes of enforcement, which means to say that India would need to give it the necessary recognition. And I forgot to mention one more criterion which India specifically requires, is that it has to be in respect of a commercial dispute. So long as all of these criteria are fulfilled, the Indian courts will allow for a foreign arbitration award to be enforced as though it were an order of the Indian court. Of course, there are certain procedures that need to be fulfilled before that, but I don't think we need to get into those specific details right now.
Thank you very much. One of the benefits of arbitration is confidentiality. I think that is one of the points that was discussed earlier. And I just wanted to ask you, Bala, that what should parties bear in mind in considering this confidentiality as a facet to international arbitration?
Right. So the starting point in many jurisdictions is that confidentiality is reflected in the Arbitration Act of the country, for example, in Hong Kong. You may find it surprising, but in Singapore, the statute does not provide for confidentiality within the Arbitration Act. Instead, it's a creature of what we call common law. That means it's implied in our laws that arbitration proceedings will be kept confidential, and that implied, the implication of law has consistently been followed. So, but if there's any discomfort in leaving that question unexpressed in, say, the statute governing arbitrations in the jurisdiction, obviously you can have a clause within the contract which provides for confidentiality, just to give you comfort. But most of the institutions such as ICC and the SIAC and the SCMA, which Jainul talked about, all of them have got express provisions within the institutional rules which says that all arbitration matters in the arbitration will be considered confidential. So much so that the documents used in the arbitration cannot be divulged. And if you take an ancillary court proceeding, whether in Singapore, Hong Kong, and so forth, even the parties' names are redacted and they're given alphabetical names such as ABC versus DEF, so that you do not know who the parties are. And if the business that they are in is particularly unique and you would be able to figure out who the parties are from the business transactions described in the judgment, that also sometimes they change the nature of the business so that there's complete confidentiality even if the matter goes to court. Yeah.
Thanks, Bala. Maybe, Ganesh, I could turn to you, because Bala was obviously speaking of the Singapore position. Maybe I could ask you to elaborate on the Indian position.
Yeah. In India, confidentiality of arbitration is now provided in the Arbitration Act. In the 2019 amendments, they've introduced a new section 42A. But the way it is worded at the moment is a little, I don't think it really, in my view, really helps, because it says the arbitrator, the arbitral institution, and the parties shall keep the arbitral proceedings confidential except for implementation or enforcement of the award. So what happens when we, take any other proceedings in court, or, any other application in relation to the award, or, for example, even to file a set-aside application? So those things aren't covered. In fact, these are suggestions that have been given by a committee which are looking at the amendments to the Act, that it needs to be quite tight. But that said, though this amendment was made in 2019, in my view, confidentiality of arbitral proceedings in India is a myth. In fact, if you go to some of the popular arbitral, venues where hearings are conducted, you have something like a court cost list with the names of the parties and which room the arbitration is being held. So I think with time, maybe this provision will work and it has to be tweaked a bit. Like in Singapore, though you don't have a specific provision for the arbitration proceedings, you do have for court proceedings where it can be redacted. So you will see ABC versus XYZ and so on and so forth. So, but that I think it's very tough for us to do it in India at the moment. Once it goes to the court regime, it's going to be in the public domain.
Thank you. Thank you. China, do you want to add to that?
Yeah. So just to tag on to the point that Ganesh made, right? In Singapore, if you have court arbitration-related court proceedings, for example, if you have an application to set aside an arbitration award, right? There are specific provisions in the International Arbitration Act, sections 22 and 23, where the court has a specific power to grant privacy orders. And I believe that's not the position in India, as what Ganesh has said. So this is where Singapore is different, right? So under the provisions of the International Arbitration Act, the court-related proceedings are by default heard in private. So that's the starting point, unless the court otherwise. So in other words, the court can, on the application of a party, say that the proceedings will not be held in private. We will not grant the usual privacy orders, such as redacting the names of the parties, sealing the court file, etc. Right? And our judgment will not be anonymized. So, in other words, the right to privacy, although prescribed by the statute, is not absolute. But the party that wants to lift the cloak of privacy must show that, for example, the award is in the public domain, the award has been published, everybody knows about it, so what privacy is there to protect?
Thanks, Chad. Now, I think there's a question from the audience which I think pulls a number of the strands that we've been talking about together. And the question is this: how can businesses leverage international arbitration to mitigate risk in cross-border transactions and protect their interests effectively? And maybe I will begin by asking Bala to comment in response to that question.
So the seat in which your arbitration takes place will of course be the most important thing, because if your arbitration takes place in a jurisdiction that is a New York Convention jurisdiction, then the award that you have can be enforced relatively easily in over 130 countries. So even if the domicile of the defendant or the person who, the party that lost the arbitration, you're unable to enforce it in that particular jurisdiction because maybe he delays the enforcement there because he's got certain influence, you will be able to have 129 other jurisdictions where he may have assets or his cash may flow through that you can attach. So you can mitigate the risk by choosing a place of arbitration which allows you maximum capability to enforce the award in numerous jurisdictions. So that'll be one way to mitigate.
Okay, I don't know whether...
Yeah, just to add on quickly, another point, choose a good arbitrator. Right? Because as we spoke about finality of awards, right? If the arbitrator or the tribunal gets it wrong, then that's too bad for you. So you want to mitigate the risk, make sure you choose the good arbitrator, a good arbitrator who has the specialized knowledge or the legal knowledge that is required to understand the case and to arrive at the right decision.
Yeah. So we talk about choosing the arbitrator, but let's be clear on exactly what it is we're talking about. If an arbitration clause provides for the appointment of 3 arbitrators, then as one party, you have the right to choose one arbitrator, the other party has the right to choose another arbitrator, and those 2 arbitrators then would usually appoint the 3rd arbitrator, and if they can't agree, there should be some way of resolving for that. But, I was speaking earlier about the difference between institutional arbitration and ad hoc arbitration. And a question has come in from the audience about what are the key differences between institutional arbitration and ad hoc arbitration, and how should parties decide which approach to take, which is cost-effective and the best option. Now, Srikanth, I wonder whether I might turn to you as the arbitrator or the person whose main practice is as an arbitrator. From your perspective, the difference between institutional and ad hoc, why it's important, why it matters, and the key differences, and how should parties decide?
I mean, I think a lot of it is actually down to the existing culture, right? I think we need to address the point that in India, broadly speaking, ad hoc arbitration still holds sway. And it's been quite an uphill task for institutions to break into that. And I think a lot of it is down to perception. While there has been a slight uptick in the number of institutional arbitrations within the country, I think the perception somewhere lies that when you have an ad hoc arbitration, the parties seem to be more in control of various aspects of the arbitration, right from appointing the arbitrator to potentially the costs involved and so on. Now, I say that because I think we need to recognize that this perception exists. But at the same time, I think experience internationally as well as more recent experience with institutions in the country will tell us that that's not necessarily the case. The pool of arbitrators that are empaneled with the institutions is vast, it is diverse. You have a number of experts and you have a number of retired judges too, which seems to be the preference in India with ad hoc arbitrations, who are part of these institutions and they're empaneled with these institutions. So on the point about the parties having more control over the choice of arbitrator, I think certainly that's no longer the case, that it's better off in ad hoc. When it comes to the question of costs, again, while parties feel that it is going to be more efficient for them in an ad hoc proceeding, it's not necessarily the case, because many institutions do have some sort of, I wouldn't say control, but they do have some sort of an upfront schedule which tells parties exactly what the cost of the arbitration is going to be. And you mentioned this in the course of your presentation as well, where you can go up onto the website of, say, SIAC or potentially one of the others, and you're able to calculate exactly what the cost of the arbitration is likely to be, at least in the range, before you jump headlong into that. I think the one other point that distinguishes institutional arbitration from ad hoc, I think I see that as a huge benefit, and again, maybe I should temper that, but at least I see it as a huge benefit, is some of the institutions do have a process of scrutinizing the award, right? Now, I understand that that's not something which parties understand completely, but I think it's important to address the point, which is that the institutions don't get involved in the actual decision-making at any stage whatsoever. The arbitrator, the tribunal which has been chosen, has complete control over what the decision is. But what the institutions try to do is to ensure that from the perspective of any egregious mistake or a calculation error, etc., it's brought to the notice of the tribunal or the arbitrator so that they have the opportunity to correct it before the award is released, and then it becomes challengeable, you see, on those grounds. So it's more about ensuring there's a basic level of control that is exercised in ensuring the quality of the award. Nothing more, nothing less.
Thanks. Ganesh, there is a question from the audience that is directed specifically at you.
Oh my God.
And it's such a good question that I have to ask you. Can the scope to appeal an award or a consent order, but let's stick to an award. Can the scope to appeal an award be widened by not keeping it just to coercion, fraud, and misrepresentation?
Repeat, sorry.
Can the scope to appeal an award be widened by not keeping it just to coercion, fraud, and misrepresentation?
Okay, first and foremost, we can't appeal an award. What we can do is to file an application to set aside an award on extremely limited grounds under Section 34 of our Act with arbitrations seated in India, and you can resist enforcement of a foreign arbitral award on similar grounds under Section 48. But there's only one subtle difference. When it's a domestic arbitration, you can also challenge it on a ground of patent illegality. So in India, what we do, though we don't have an appeal on a question of law like in England under the English Arbitration Act, or in Singapore under the Domestic Arbitration Act in Singapore. Singapore has two enactments. International, it has International Arbitration Act. For the domestic arbitration, there is a separate act called the Arbitration Act. Under the Arbitration Act, you can appeal on a question of law. In India, though we don't have a provision for appealing on a question of law or a general appeal, a lot of these issues of, egregious errors that Srikanth was referring to is brought under patent illegality, which is still kept. The patent illegality concept was introduced in the ONGC and Sawpipes case, where, you could bring these things. But if you look at fraud and other aspects, one issue of fraud is, it goes to the question of arbitrability itself. So if there's an issue of fraud, you need to perhaps challenge arbitrability. There's a Supreme Court judgment in, Ayasami versus Paramasivam, where the Supreme Court has made a distinction between mere allegations of fraud and serious allegations of fraud. If it's mere allegations of fraud, the Supreme Court has said that it is arbitrable because any reluctant respondent can allege fraud. The serious allegation of fraud, and let's say it attracts provisions of the penal code, then of course the tribunal can decide. But at the end of the day, the arbitrator is the master of the proceedings and he has to decide whether it's arbitrable or not. And if the arbitrator does decide, even though it is a fraud issue and it is decided, still you can of course bring it under 34 saying it was beyond his jurisdiction and all that. So you can still challenge it on very limited grounds provided in 34. If you think it's patently illegal, you can still bring it under 34. But I would say it's not going to be a very easy task, considering that the Indian courts now have become very pro-arbitration, and setting aside an award unless it's clear violation of any of the provisions of 34 is not going to be easy.
Thanks, Ganesh. Jainil, maybe I'll throw you as well, which sort of follows on from what Ganesh was talking about. What if the parties were to agree, as in their arbitration agreement, that the courts of the seat shall have the right to appeal, to sit on in appeal on an arbitration award on the application of the parties?
So what you're saying is that the contract specifically provides that you shall have the right,
appeal,
or you can appeal. That would be contrary to the Act in Singapore. Because what the Act says is that you need to rely on one of the specific grounds that, as we have mentioned earlier and discussed earlier, to set aside the award. So if you don't satisfy any of those grounds, right, you can't set aside the award.
Yeah. No, in India there is a case, but of course it's called Centro Trade, Supreme Court judgment, where they had two-tier arbitration clauses. So you have a first round, and for the second round of appeal, you go to a different institution. But it was challenged saying, how can you do that in an arbitration? But Supreme Court upheld saying it's party autonomy.
Yeah, but you see, you can provide, for example, in your rules, in the arbitral rules, there is a right of an appeal. For example, GAFTA, Grain and Feed Trade Association, right, in the arbitral rules, right, those rules say that if there is, there is an initial tribunal that's constituted, and if a party is dissatisfied, it can appeal to the Board of Appeal. Similarly with BORAM, there is an appeal board. So in that situation, yes, right, of course you can go through that process and you can appeal the award. But once you have a final decision from the Board of Appeal, from GAFTA, and you want to come to Singapore to set it aside, then you need to satisfy the Act. Okay?
Thank you for dealing with those questions so well. And I must say thank you to the audience for all these questions, because they are fantastic. We haven't finished yet. We've got a little bit more time. I do want to turn to a slightly different topic, and more about the practicalities of actually prosecuting an arbitration. And maybe if I could first ask Bala, as a person who has a tremendous amount of experience in shipping maritime disputes, and having done both court litigation, an extensive amount of court litigation, an extensive amount of international arbitration, what do you think the differences are in terms of the advocacy in these two processes?
So while arbitration is adversarial exactly like how it is in the court proceedings, the advocacy in terms of eliciting the facts is a lot more, to use one of a better word, gentle. In court, the cross-examination can be theatrical sometimes, and you can have a very domineering counsel. You can have a counsel that tends to bully the witness. But in the international arbitration setting, quite often, because the arbitrators are selected from forums which are very different from ours meaning Singapore, UK, India, where we had inherited witness in the witness box kind of a setting. In the European culture, it is less adversarial like that. So some of the arbitrators who have had experience sitting with arbitrators from a different culture, particularly the European culture, they do not like domineering questioning tactics. They sometimes take it as a weakness in the case that is being masked by a very arrogant or aggressive advocate. So you will have to read the arbitrators quite carefully when you choose that method of cross-examination. So cultural aspects, you need to be quite attuned, because if you treat it like exactly like a criminal case that you would do in the local courts, it may not bode so well for your client, because certain impressions may be formed by people from different cultures.
Thanks, Bala. Srikanth, I wonder if I might ask you to follow up on that. Again, from your perspective, sitting as arbitrator, what to you is the difference?
I mean, I think Bala touched upon it by just elaborating. One of the things that, in an international context especially, that counsel should be prepared for is that the arbitrator tends to be extremely familiar with the submissions beforehand, well before the oral submissions begin. And so invariably, the arbitrator would have given a certain set of hints at least in terms of where he would like to be specifically addressed on what issues. And therefore, counsel would do well to pay heed to that and ensure that rather than repeat or have his own set of submissions, try and address what the arbitrator has indicated he or she would like to be addressed on, right? And that's something which to some extent happens in a court of law as well, but more so specifically in international arbitrations, where the tribunal is extremely well prepared before the actual date of the oral submissions.
Thank you, Srikanth. Just to add to this, from my perspective, one of the critical differences, and I think it's manifest particularly in jurisdictions like Malaysia, where I practice, along with Singapore, is the importance that is placed on written advocacy in arbitration. That is, I think, a key takeaway and a key difference with respect to how things are conducted in arbitration proceedings. And that sort of links to the subject of case preparation in arbitration. And maybe, Ganesh, I can ask you to perhaps provide your comments on the importance of case preparation. Even what does case preparation entail in arbitration?
Right. I see many of our colleagues here, practice in the High Court, which is mostly appellate jurisdiction. And in India, which is very unique, most of the practice of the High Court lawyers are prerogative writ petitions. It is your mandamus, your arrays, which is not the case in Singapore. In Singapore, very few matters like that go to court, mostly civil actions. But here, majority of the practice at the High Court level is mainly that. And you do have civil side, which is unique to only 5 high courts in India, which is Delhi, Bombay, Madras, Calcutta and Himachal Pradesh, where you can directly go to the High Court for a civil suit beyond a certain amount of money. In all the other states, you have to go to the district court or the city civil court as appropriate to file a civil suit. Arbitration is nothing but very similar to a civil suit. And in a civil suit or in an arbitration, you have to be a master of the facts. See, sometimes when we go to lawyers and we say, hey, just a legal issue, natural justice has been violated in this case. Immediately they say, oh, Menaka Gandhi versus Union of India, 19 AR, 1978 Supreme. First, what is the fact? What according to you is the natural justice that has been violated? So we need to get to the facts completely thoroughly in an arbitration. You need to know the entire pleadings and the documents clearly, and then you apply the law to that proceeding. I think that is something which I find that here maybe we are all too busy running around in court and sometimes we don't have enough time to focus. We need to know the facts thoroughly. If you do that, half the battle is won, right? So when it comes to case preparation, I think that is really, really important to know the facts really well. And of course, then you talk about advocacy. I think Avinash made a very important point that in arbitration, be it in India or even in international arbitrations, most of it is in written advocacy. So you do have to write your pleadings. Everybody wants now a written submission after the trial is over. And unlike in international arbitration, where once your trial for cross, you have a very short closing. But in India, we have a separate few days for your legal arguments. And sometimes you do your written submissions and legal arguments, finish your legal arguments, then give your written submissions. And it's extremely important that we should, focus on these areas for preparation. Facts, extremely important. Of course, law is equally important. But I think from my experience, we miss out a lot on that. We straight jump and not focus too much on the intricacies of documents and facts, which thorough preparation is very much required.
Thank you, Ganesh. Just to add to that, I think in the context of what we're now increasingly seeing across, which is expedited arbitrations, this becomes even more important because you don't necessarily have the time to have extended hearings and so on. So when you get into an expedited arbitration, especially because now you see many institutions raising the bar, as Avinash said, in terms of the quantum of the dispute that is covered under that, it becomes all the more important that you focus on the written part of your submissions.
Thank you, Sridhar, because that sort of links directly to the last question that I'm going to pose, and maybe Daniel, I'll ask you to answer it. So it's with regards to expedited procedure specifically, and the question is, how does a practitioner go about presenting their case, researching and examining witnesses within 6 months, especially since construction contracts go for almost thousands of pages, spanning years of communications? Maybe, you could go on, maybe the shipping contract.
A short answer to that, if that is the nature of the dispute, it's not suitable for an expedited procedure.
Well,
but if you want to take it up on an expedited procedure, then you better be prepared. So that's one thing. Now, arbitration is consensual, right? So actually parties can agree, for example, that we are taking an expedited procedure, right? And we go by documents only. But if one party says, no, I don't agree to documents only because I want to examine the witnesses, the issues can only be properly determined if the witnesses are cross-examined. Then in that situation, the tribunal, unless the rules specifically empower him to do so, will have to have an oral hearing. And then you probably will find it very challenging to get everything done within 6 months.
So I'm just going to jump in here and say that we just do it. We do it, and we've become very. We know how to run the case now, so that we can get it done within that 6-month period. It takes a lot of effort. It takes a lot of planning in advance, and it is intense, but it can be done. And I'm talking about a full case all the way to the end, including an evidential hearing.
Thank you. I think subject is such we can carry on going. But this is only a teaser. We'll bring you more seminars as Justice suggested. We'll have a off-day seminar soon. But more people can come and more interaction can. Ladies and gentlemen, big round of applause to this panel this evening. Daniel, Avinash, Ganesh, Srikanth and Bala. We also thank Justice who could not join us in person. But since we were separate by distance, we made a memento for him. Can I have the online memento, which will be given to Justice? What we do is, on behalf of him, we give to the poor students books and other items, so that because people like him come and speak, that is what brings people here. And may I also request you please step forward and accept a token of our appreciation from MMA. What we are going to give you only some more books, and what we are also going to give you, thing where you have to drink so much of water because you keep talking for it. Thank you, ladies and gentlemen. Thank you, viewers. We have got over 820 viewers watched it online. Thank you for so many questions. I've only given 50% of the questions what we came online. Thanks so much for everything. Thank you, ladies and gentlemen, who joined us this evening. And till we meet again, bye-bye and good night. The speakers are available here for you to interact. Thanks so much.